Hello, everybody. Thanks for joining us for today's webinar. I'm Trent Taylor, and I'll be sort of your MC for our webinar this afternoon or morning, depending on where you are. We have a huge crowd today, so I really appreciate your attendance. And as always, our goal in our quarterly webinars is to hopefully provide you some helpful information while also being at least hopefully a little tiny bit entertaining as well. And as we always try to say at the beginning of one of these, if you have questions, feel free to use the Q&A feature at the bottom of your screen, and we will try our best to answer them during today's webinar. And if we can't get to it, then we'll answer them afterwards. And as always, if you think of a question later on, feel free to call or email us. We're happy to talk or answer any questions anytime. So our theme today is pumpkin spice. Now, as most of you probably know, we usually do a Halloween theme in the fall, but we get bored easily, and we wanted to be a little extra. And when I say we, I really mean Jenny and Royce, but it's fantastic. And why pumpkin spice? Because as these cartoons show on here, pumpkin spice is everywhere, right? I mean, consumers apparently love it. So we figured maybe if we branded our webinar as pumpkin spice, it would increase our attendance. And lo and behold, it's worked. We have a record crowd. So that's fantastic. Here's our panel. It's the same panel we usually have on here with one addition. We have Alicia O'Brien, who is in our LA office, and she's stepping in to take over the Prop 65 piece. So welcome to her. And wait a second, I'm actually being told that we plan to have a special guest help with Jenny's presentation. So we look forward to that, and we'll see who that is here in just a little bit. We have our typical roadmap. I'm going to start off with a few housekeeping matters as well as some trends from 30,000 feet. Then we're going to turn it over to regulatory, then product labeling, then food and beverage labeling, followed by Prop 65. One housekeeping matter that I wanted to mention quickly is we plan to send out an email survey to all of our attendees here today in the next week or two, just asking for some feedback on our webinar. And we hope that will help us improve and hopefully be more targeted in discussing the things that matter the most to you. And to incentivize you to complete the survey, we're going to send everyone who completes the survey a card redeemable for a pumpkin spice coffee drink. And if you don't like pumpkin spice, that's fine as well. Don't worry, we will not tell anyone. We will not out you. You can use it to buy a less interesting coffee drink. We also have a giveaway today, and you may recall we did a giveaway last time as well, and I wanted to recognize and give a congratulations to Brian Marquez with Tampico, who won the blueberry cheesecake from last time. Today's giveaway is 12 pumpkin spice bonbons that are shaped like ghosts from an acclaimed artisan chocolatier. Now, one question I have that Ben can maybe answer a little bit later in his section is pumpkin spice just a flavor here, or does it actually mean there is real pumpkin in there? And I cheated and actually looked at the ingredient list for these bonbons, and there actually is real pumpkin. Ben can tell you a little bit about why that matters in a little bit. Before we get into the actual content, I wanted to play a quick little game, okay? And because pumpkin spice is in just about everything these days, it makes for some interesting combinations. So I want to see who the real pumpkin spice experts out there really are. So what I want you to do is we have 5 or 6 slides real quick with some products. Some are real, some are fake. I want you to guess which ones are real, which ones are fake. Keep track. It's on the honor system. I'll give you 3 seconds on each of these and keep track. And if you want to tell us your score in the Q&A section, you should feel free. So the first one up is Cup of Noodles, pumpkin spice flavor. So is this real or fake? 1, 2, 3, this is real. Okay, so it's an interesting flavor, but this is something that is really out there. Next one, pumpkin spice Twinkies. 1, 2, 3, real or fake? Okay, this one is an easy one. This is definitely real, and I have seen this at the local grocery store and was tempted to pick it up even though I didn't. Next one, pumpkin spice Kool-Aid. 1, 2, 3, real or fake? This is fake. But I must say it's entirely plausible. Seems like something that could be real. Next one, Wrigley's Extra Pumpkin Spice Gum. 1, 2, 3, real or fake? This is real. And it seems like a really good idea. I could see buying this and having some gum that are pumpkin spice flavored. All right, Spam, pumpkin spice Spam. 1, 2, 3, real or fake? All right, this was a hard one. I thought for sure this was real, but very disappointed to learn it's actually fake. Pumpkin spice Jello. 1, 2, 3, real or fake? This one is real. This one is a real product. And then the last one, pumpkin spice bologna. 1, 2, 3, real or fake? Okay, this one's fake, and this maybe seems like a bridge too far. So if you want to post and tell us how many you got right in the Q&A, then you should feel free to do that. Now, moving on to our actual content today, I'm going to talk for a few minutes about some trends. And one of the things that you probably know is we try to keep track of every single labeling class action that is filed. And we've recently upgraded our system to make it more robust. So we're more confident than ever that we are capturing every such class action, whether it's filed in federal or state court. And sifting through the numbers related to those class actions is very interesting, and I wanted to share some of that data. So first of all, since June 1, there have been 139 labeling class actions, and it's actually 140 because one was filed late last night in the Northern District of California related to veggie burgers, so it's actually 140. But what's really interesting from our data, and as you can see in the pie chart, is it's almost evenly split between cases that are targeting food and beverage products versus non-food and beverage products, such as cosmetics or personal care products. And as most of you probably know, traditionally, there's a lot more of these cases that target food and beverage products. But we've seen a growing trend toward non-food and beverage products, and we've been predicting for a while now that was going to increase, and I think it's finally. So this is suits against clothing manufacturer, beauty products, deodorant, sunscreen, skin cream, batteries, trash bags, mouthwash, etc. And the Plaintiffs' Council, they're using the same playbook they used on food and beverage labeling class actions, and are now using them on product labels. So we expect to see a lot more of that. So where have these class actions been filed since June 1? As a lot of you probably know, last year, New York led the way, but not this year. Once again, California reigns supreme. But what's really sort of interesting is Illinois. Illinois has really rocketed up, and there's been a huge increase in the number of cases filed in Illinois federal and state courts, and it's on pace for an 8-fold increase over last year in terms of labeling class actions in Illinois. We're going to talk in just a minute about why that is. And here are the plaintiffs' lawyers who are filing labeling class actions. And on the far left, Spencer Sheehan, and he's why there's been that huge increase in Illinois. And most of you probably know he's the guy who filed all of the vanilla, or at least most of the vanilla cases in New York courts over the last 2 years. He is now changing tactics. He is now filing in Illinois courts, and he's varied that some Northern District, some Southern District, some Central District, some state court. And he's expanded out from vanilla to focusing on other flavors and ingredients, such as lemon, fudge, a number of fudge cases, a number of cases against Pop-Tart manufacturers. And he's focusing on smoked as the flavor as well. You can also see the other ones, Bursar and Fisher. They do focus a lot on products. Jason Stolzer, who focuses entirely on products and only files in New York courts, mainly state courts. And then Guttridge and Safier, who've been raising their profile. They've been around, but they've been raising their profile and filing more of these in recent months. And now they're on this list of the most prominent ones filing the suit. And I actually know Seth Safier, who's the one filing these. He was actually in my section at law school. So why does this matter? It matters because these guys, they set the agenda for the other suit. And they're more prolific, and other plaintiffs' counsel see what they're filing, where they're filing, and then they file their own suit, sort of copy these. One sort of note, we know all of these plaintiffs' counsel. We've gone against them. We know their playbook to a certain extent. If you ever want to discuss, you should feel free to give us a call up, and we're happy to discuss and what we know about them. Okay, so products targeted by class action labeling suits since June 1st, and we can make this pretty short. Beverages remain one of the big targets, and that's seltzer, water, tea, coffee. We also have the beauty, cosmetic, personal care. Been a lot of those. Sunscreen, which Jenny's going to talk about here in a little bit with her special guest. Breakfast foods, Pop-Tart cereal, breakfast bars, that's mainly Spencer Sheehan. He's been targeting those, as well as some of the snacks, yogurt, cookies, chips, crackers, popcorn, almonds, and onion rings, which, seems un-American to me to go after onion rings. So that's the products targeted by class action labeling suit. What are the labeling claims that have been targeted? So ingredients, that includes flavor. So, fudge, is it really fudge? It's really the big one. Natural remains a big one as well. But what's interesting about that is that's often in the product context now and not the food and beverage labeling context. So because so many folks have moved on from using natural and food and beverage products, but there's a lot of non-food and beverage products that still use natural, and Jason Stolzer in particular is going after them in New York State courts. Country of origin is something Ben's going to talk about here in a little bit. That seems to be increasing now. We've always had those, but it's increased. And that also includes some product labeling. And then environmental fair trade is another big one. That is stayed steady. I think it's actually a little bit. That's, I think, the future, and we're starting to see that number trickle up as well. Here's just a screen, a takeaway real quick for you. As most of you know, or as I mentioned, there's been a huge increase in the number of product labeling class actions. If you have a non-food and beverage product that you sell, now is the time for reviewing those labels, because those are becoming targets. And then for the food products, the ingredient claims such as lemon, lime, smoked, berry, whole grain, butter, fudge, you have product with any of those ingredients or flavors, you want to be reviewing those and being hyper technical in terms of regulatory compliance. If you don't, you may get a lawsuit filed against you by Spencer Sheehan or someone else. And finally, this is just, I'm going to move quickly because I've run out of time. One thing just to say, Ninth Circuit, here's some interesting cases from the Ninth Circuit. It's long been a thorn in industry side, but there has been a shift, and there have been some very helpful Ninth Circuit decisions this summer, including the top one, the Moore case, which expanded the reasonable consumers. So with that, I'm going to pass it off to Kate and Royce.
Hey, Kate, do you want to go first, or do you want me to roll?
No, go ahead. You can start, Royce, and I'll chime in.
To our fans out there, welcome, and thank you for listening to our segment. Some just preliminary things. Yes, I am wearing hemp pants today, and they're made of cannabis. So that's kind of like my my webinar setup right now. And sorry, I'm not on video, but wanted to talk briefly about kind of what's going on with, kind of the regulatory environment out there besides listening to COVID-19. And we've had a lot of developments that Kate and I will get into, both on the agriculture, food, and cannabis side. And one of the first developments that I kind of wanted to bring up is, where are we with the whole cellular-based meat debate with USDA? We saw a lawsuit out there by the Cattlemen's Association, it wasn't a lawsuit, but a petition. And USDA is now seeking comments on how best to regulate cell-based meat through a notice of proposed rulemaking. And if you think about it, it's not really that USDA doesn't know how to regulate meat. It's more USDA doesn't know what they're going to do when labeling this. And there's a memorandum of understanding between USDA and FDA on this issue. And that MOU kind of just, it rehashes the basics of where that squiggly amorphous line between USDA and FDA regulated industry is, but related to cell-based meat. So some of the issues that you can think of that are raised in the notice of proposed rulemaking, and if you email me, I'm happy to forward that along, are, what do you do with a blended product that's, 50% like ground chuck or, ground sirloin and cell-based sirloin? What are the standards of identity here? There are pretty well-defined standard identity for meat. How do you label it? What do you do with products that are, cultured with cells from other foods as well as meat? And these are the questions and the opportunity right now to get ahead of this. If you have an opinion that you want to express to USDA, now is the time to do that, or else they may regulate or label in a way that isn't great for your industry. Just kind of moving on here, I'll let Kate take this one.
Great. Thank you, Bryce. So on the next couple of slides, we're going to cover topics that we've covered before. We're going to focus on Delta 8 and then some new developments in state law with respect to regulating hemp and CBD. On the first topic for Delta 8, that's one of those things you can't miss it. Since hemp products have been out there, I feel like on every street corner, you're seeing a lot of people advertise that they're selling something with Delta 8 and basically saying it's hemp derived, therefore it is completely legal and it's fine, which is not the case. Just a few days ago, both FDA and the CDC published information warning of the health risks of Delta 8 products and asking consumers to be careful. And just to go over the different types of Delta 8 products that are out there, and I think right now in the commercial market, you'll see everything from vapes to smokable Delta 8 to tinctures, gummies, and any type of infused food or beverage product. So there are quite a bit of things out there. In general, the Delta 8 is derived from hemp. One of the biggest issues, because this is not regulated at all, some companies are using other chemicals or synthetics to convert the product into Delta 8. They're adding in harmful metals and other things, and that's really been the biggest issue. One thing to note, both in the CDC and FDA publications, which if you need a link to those, we're happy to shoot that to you. Just in the last 6 months, there have been many reports to both the National Poison Control Centers and just state poison control centers of adverse reactions from people taking Delta 8. Some of those reactions, just to summarize, are reported as unintentional exposure. People didn't realize what they were taking. A good percentage of these, almost 40%, involved pediatric patients. Those are most likely, the gummies, et cetera. According to the National Poison Control Center, 18% of these resulted in hospitalizations. And those are just what's reported. I think the bigger concern is, what's not reported. So I think it's just something to be aware of. Also things to be aware of, state cannabis boards. This is, of course, outside of hemp and into state-regulated cannabis. There are rules from that perspective and regulations as far as whether or not Delta-8 products can be sold in a medical or adult use cannabis dispensary. Certain state laws now, just over the last 6 months, have also come out and adopted laws that expressly prohibit Delta-8. DEA's position as well is currently that Delta-8 falls under the Schedule I controlled substances and is flatly illegal. So there's a lot of different regulatory things to be considering out there. Just because you see it in the market does not make it okay. And I'll just real quick right here too, for more information on kind of more of the cannabis outside of the food side, Royce and I have, there's our Edible Bites video blog or our In the Weeds email updates if anyone is interested in more information there. And I'll move quickly to just talk about California finally passed AB 45, which has been floating in and out of the legislature for several years. It's been hotly debated. Finally passed the legislature. As of this morning, it's still sitting on the governor's desk for signature. But this bill addresses how hemp products will be treated in food, cosmetics, dietary supplements, and actually pet food if they're sold in the state of California. There's quite a lot to this bill. Couple of the highlights that we wanted to point out, the bill does require registration and fees. There are very specific rules for labeling both on the cosmetic, food, and supplement side. One thing to point out as well, this does not cover hemp-derived products in nicotine, tobacco, or any type of alcoholic beverage. There is a provision in the bill that addresses inhalable products, which is something to parse through. There are quite a few rules on advertising restrictions, advertising requirements. Interestingly, the bill has an explicit requirement that you put on the product. FDA has not evaluated this product for safety or efficacy, which is different than the standard to share requirement that goes on a lot of things. So there's quite a lot to unpack there. Other things that are addressed in the bill are, in addition to advertising, are testing requirements, certificate of analysis. The bill also provides for specific recall authority for products. The last thing I will quickly mention, this does seem to contemplate in the bill that the state will go outside of the state to inspect facilities that are manufacturing hemp in another state, but putting their hemp products into the state of California. And there's actually fees that may be associated with those inspections. So, Royce, did you have something to add there? And then I'll turn it over to you to the next slide.
Yeah, absolutely. So I think we have to think globally about, why do all these cannabis regulations matter? And it's really because if you look at it, standard THC cannabis industry has just extensive regulations on quality, purity, testing, and grow. And both Delta-8 and, food products represent kind of loopholes, backdoors that were always, in the eyes of the regulator available for people to get into the cannabis industry and are not held to the same standards. So this is, a natural shift for regulators, whether or not it's good or bad, to, get in there and start taxing, regulating, and, controlling all aspects of cannabis, which they had previously done on the THC side. So, with that said, just moving quickly to if you think about it, 15, I think, out of 43 of our slides are dedicated to California, just to tell you something there real quick. But California Proposition 12 is the silent thing that I don't think gets enough attention in the media or elsewhere. Basically, Prop 12 is the requirement that both chickens and pigs are held, this is very general, chickens and pigs are held in humane conditions. And California, on January 1, 2022, will begin enforcing the pig requirement of 24 square feet. So if you are a pig farmer in Iowa, which is what some of these unfortunate lawsuits that didn't, go all the way have, you are going to have to consider, do I want to risk selling meat in California on the basis of enforcement? Because California will now be regulating the entire, essentially conditions of where my pigs are grown, even though I'm in Iowa, if I want to sell into that market. So unclear how this is going to play out at the end of the day. I think there is an economic impact here. I think especially with COVID-19, there's an economic impact. And although there are UC Davis professors out there that don't think there is an economic impact, I think that we are going to see disruptions in the supply chain, maybe not to a major extent, but to some extent. And turn over my colleague or special guest who is going to appear on this one.
Thanks, Royce. Hey, guys. I'm Jenny Price with my special guest, the squishable pumpkin spice latte. I could not believe my eyes when I saw this when I was traveling for work last week. It's literally the cutest pumpkin spice latte I've ever seen. It's also the largest. I don't know that I could drink all of this pumpkin spice latte, and I love pumpkin spice lattes. But anyways, this is my special guest that I just had to bring to show you guys because I thought it was just the cutest thing I'd ever seen and fit right in with our theme for today. But it's good to be back with you guys. I'm going to talk about product labeling litigation updates, just like I always do. And Trent added this slide in for me, and indeed, pumpkins and spice are the power couple of the hour or of the season. I personally am growing some pumpkins at my house, so they're really, really the having a moment with me right now. So I wanted to go back to one of the trends that we had initially spotted on one of our WebExes about the potential changes that the Biden administration might be bringing. And we had identified an increase in FTC and FDA warning letters. And the little graphic right there from the 8-ball, it is decidedly so. There has been an increase in 2021, just like we predicted, in the number of FTC and FDA warning letters that have been issued. That's particularly true with COVID-19 and CBD claims. Just a lot of warning letters involving claims that companies have been making regarding efficacy of products in combating COVID-19 or on their CBD claims. And this is important because, as we've talked about on other webinars, is that litigation tends to always follow FTC and FDA warning letters. They're usually a warning letter goes out and quickly lawsuits are filed, class action lawsuits are filed. And we have seen that remains to be true. We first talked with you guys about this in the hand sanitizer arena that actually was pre-COVID, believe it or not. The FDA warning letter on hand sanitizer went out just before the world shut down for COVID, but that trend has continued, and you see that with, air purification systems like Molecule has gotten several class actions and several copycat class actions that have been filed against it, and that's a consumer air purification system. So what is our practice tip on this? And I'll sound like a broken record on this throughout today, but it's substantiation, substantiation, substantiation. So if you're going to be making claims about your products, either how they work or what's in them, you need to have that substantiated to make sure that it is in fact true before you're labeling your product with either efficacy claims or, how much horsepower your product may have, or what is in your product. Just make sure that you do have that substantiation and that it's well documented. The next update is one that we've talked about in the past as well. We've seen a lot of litigation over labels on products claiming that it's been made in the USA or made in America, something similar to that, and even made in Hawaii or made in France. But I wanted to at least flag for you that the FTC in August issued its final rule on made in the USA. I have the site for you there. It's 86 FR 370022. But the takeaway from that is that it really is just issuing the final rule on sort of how FTC has been treating Made in America, which is that it prohibits marketers from including unqualified U.S. origin claims. So this is specifically talking about unqualified U.S. origin claims. If you have a qualified U.S. origin claim, which basically means like you're listing out what percentage of your ingredients come from where, that's considered a qualified U.S. origin claim. But if you have an unqualified U.S. origin claim where you're just putting, the label on made in the USA, but you're not specifying, what percentage of the products come, then this is an important final rule that you should probably, familiarize yourself with. But it prohibits including that label unless the final assembly or processing of the product occurs in the United States. All significant processing of the product occurs in the United States, and all or virtually all of the product's ingredients or components are made and sourced in the United States. So, they didn't really give a great definition of all or virtually all, and basically just said that they would be adopting how they'd previously enforced that before. But I at least wanted to flag that for you because that is something that we see oftentimes either made in the USA, made in America lawsuits, or, made in Hawaii or made in France, et cetera. So it's important, again, to substantiate those types of claims. Oh. I think some of my slides might be actually missing, but I will just talk to you about a couple other interesting trends that I wanted to flag for you. So one of them is the Pfas litigation. We've discussed that with you guys before through an Amazon case. There is a ton of Pfas litigation that is occurring across the country right now. And the slide that I had prepared for you discussed that Pfas may in fact be, in my opinion, the new asbestos type of case. Lots of manufacturers and distributors are being sued over Pfas. And it is a chemical that's used in a wide variety of products, from things like water repellent clothing to fast food chains sometimes use them in their food packaging, to popcorn bags, to plates, to fire retardant that's used in putting out fires. There's just a lot of different potential products that have PFAS in it. And it's interesting in that part of the analogy with asbestos is that the science behind it is just really developing as far as the causation. And I know asbestos has been around forever, but it took a while for the science to kind of catch up and there to be a causation argument. And right now you're seeing a lot of class actions that are brought on behalf of townships regarding the PFAS staying in the water and contaminating the water But I think that we will continue to see a large variety of PFAS litigation against a lot of different types of manufacturers and potentially distributors, and also in a lot of different types of products, not just, like fire retardant. But I think if it's in, any consumable, any consumer product, then we'll likely see a lot more PFAS litigation. And then the next area I was going to talk to you about is a trend regarding sunscreen. And I'm sure you guys all saw this summer that there was a big recall involving Neutrogena and Banana Boat, and mainly I think it was from Johnson & Johnson's product line. But essentially a third-party testing agency had tested about 78 different types of products, and discovered that about 27% of the samples was contaminated with higher levels of benzene. And benzene is a known carcinogen that can cause leukemia. And so Johnson & Johnson did a voluntary recall of 5 of their aerosol spray sunscreens due to elevated benzene levels. And that has resulted in about 12 different class actions that have been filed across the country, 2 in the Eastern District of Missouri, 2 in the Central District of California, 3 in the District of New Jersey, and then also in the Eastern District of New York, the District of Connecticut, the Northern District of California, the Southern District of New York, and the Southern District of Florida. Interestingly, these were all filed by different plaintiffs' attorneys, so there's not like a common plaintiff's attorney that's filing all of these lawsuits, but not surprising after a voluntary recall like this that you would you would see, uptick in class actions, but we definitely are with sunscreen, and I think that will probably continue. One other interesting aspect of the sunscreen litigation is that Johnson & Johnson had stated that benzene was never an ingredient that they put into any of its personal care products. And so our practice tip is to just make sure that, companies are testing products and hiring professionals to do laboratory testing if there's a concern about benzene being in any of the personal care products like sunscreen. And then obviously, again, broken record here, but substantiating that, that testing that demonstrates the levels of benzene. And I think that I will go ahead and pass it to Ben. I'm sorry that my slides weren't available on the PFAS and sunscreen, but hopefully I was able to keep you interested. Ben?
Thanks, Jenny. Hey, everyone. Ben Abel. I'm an associate in our Charlottesville office, but I am coming to you from a hotel room outside of Milwaukee, Wisconsin. So nice to join all of you. And I will just provide some brief updates on various food and beverage litigation trends that we've seen in the most recent round of litigation decisions and things getting filed and what's going on. So with that, at some point we will stop talking about flavoring lawsuits. I don't know when. I don't know what will cause that to be, but you got to keep on believing. And at some point these won't be out there, I hope, mostly for your sakes. But these suits that we've now been talking about for 2 years continue to be filed. I would say, or without empirical evidence at my fingertips, they've slowed some, but they continue to be filed. And again, for those of you who may not have a background on these, first of all, you're lucky. Second of all, the basic allegation is, for instance, the most classic example of this was a vanilla lawsuit that says, you have a PDP that says vanilla almond milk and it just says vanilla almond milk on it. And if you turn it over, the ingredient list says it's flavored with natural flavors. And over 100 of these suits have been filed that basically say if you label almond milk, ice cream, oat milk, energy drinks, whatever, with vanilla, that tells the reasonable consumer that the product is flavored with vanilla bean or vanilla extract, and it's deceiving if it's flavored with something else. And those suits have continued to be filed. They have overwhelmingly been unsuccessful anytime that a court has actually looked at the claim on a 12b6. There's a bunch of reasons that Trent and I and others on the call spent a lot of time explaining why it's not deceptive. But basically, all the courts have said if you see vanilla almond milk, a reasonable consumer thinks they're going to get a product that tastes like vanilla, and no plaintiff has claimed they don't taste like that. But aside from that, these claims have expanded into mint and to smoked almonds that are not flavored with the smoking process. Any flavoring claim, this is what Trent was saying, if a pumpkin spice product, if it's flavored with something that tastes like pumpkin, can it really be called pumpkin spice? And these traditionally were filed only in New York and New York federal court. They expanded a little bit to California. They've been filed more and more in California, but we've also seen these claims in a number of other jurisdictions, Illinois, Wisconsin, Massachusetts. We've also seen now a couple different plaintiffs, attorneys who, other than Spencer Sheehan, who was in Michael Reese, who were the two who brought the lion's share of these, have started to bring these suits on their own and have put their own unique spin on them. And in the Massachusetts cases, for instance, the claim, near as we can tell, is that plaintiffs have now said, well, the prior suits all said that the product needed to be predominantly flavored with vanilla, and they're not. Even if vanilla is a part of it, it's a minute part of it and is therefore deceptive. And we, the new Massachusetts plaintiffs, have now said there is absolutely no vanilla in the product at all. But also have seemed to at least make something of an argument saying that vanilla extract and vanilla are different products entirely. And so if there's vanilla extract in the product, that means that there is no vanilla because vanilla extract and vanilla bean being two entirely different things. These continue to evolve, and as we continue to work and defend them, figuring out new and exciting ways to say, no, the product tastes like vanilla, and getting the courts to agree with us. Like I said, those have remained overwhelmingly successful. Just this week, in the Parham case, which we've worked on, that was a report and recommendation that was accepted by the district court. So you kind of get a twofer in the sense that you've got the magistrate's opinion below and the magistrate judge's opinion below, and then you have the district court accepting the report and recommendation. That court also dismissed the claim with prejudice, saying that they didn't get an opportunity to file another amended complaint, which was a win. And so we overwhelmingly see those. But we have one claim that we saw succeed in a single count, not a single county. I apologize for the typo there. But a single count. Under California's UCL, there is a claim that basically says if something is unlawful under another statute, then it can be a cause of action for a private plaintiff. And the court in the Nacarino decision said theoretically the flavoring claim could be could succeed as violating FDA regulations, and so that was allowed to proceed. All the consumer deception claims were dismissed for all the reasons we've seen them dismissed in every case. But it does mean that no longer, if you're defending one of these claims or have one of these claims, can you say we've never seen, at the 12b6 stage, a case not dismissed in its entirety. There's one in California that had this one very minute, tiny claim get carved out and proceed. It also is important because, for instance, New York's general business law, Massachusetts Chapter 93A, don't have this similar unlawful prong. And so to the extent, and we haven't really seen much briefing in other cases since the Nacarino decision, but to the extent that plaintiffs rely on that one and say, see, these claims can go forward, in Nacarino, the consumer deception claims themselves were dismissed like every other case. Ginny talked a little bit about geographic origin suits, and so I won't spend a ton of time talking about them here. But we do continue to see made in the USA claims, as well as other claims that focus on where a product is from. And as we've discussed before, these kind of divide into two camps, whether you're saying that a product is from an area or region, or you're implying that a product comes from an area or region, versus this is in the style of. So, come visit our brewery in San Francisco, California, but the beer is actually brewed in Minnesota, might be deceptive because that suggests that the product is brewed somewhere it's not, versus this is Jamaican style lager, and that those kind of claims. One update on that is the R.C. Bigelow case, which involves tea. It was interesting because the claim on the label, the one that was really focused on, was what is bolded here, which said in kind of one big block text, manufactured in the USA, 100% America family owned. And plaintiffs said that is potentially deceptive to a reasonable consumer because the 100% could apply to the manufactured in the USA part. And what Bigelow said, at least in part, was no, the 100% relates to the 100% American family owned. And the court said, I can't decide that as a matter of law in the 12b-6. And so for all types of claims, but certainly for these type of origin claims, it's important to think of something that seems clear to you as a labeler, as a manufacturer, what the 100% in this case relates to. How might someone else read that? And could they say it applies to something else, or is it unclear, or could it potentially be ambiguous? Because a lot of what was relied on there was the fact that the judge said, I can't tell you that a reasonable consumer would or wouldn't apply the 100% to the left as opposed to the right in kind of this block statement. Contrasted with the Canadian Vet Endeavors decision, which is in Hawaii, which relates to Hawaiian-style kettle chips, which some origin claims survived the motion to dismiss, but on class cert, the class was not able to be certified. First is to California because deposition evidence basically showed that the plaintiff, the California named plaintiff, basically found out about the claim in the attorney's office and was effectively all but recruited to be the plaintiff. And that was not typical of the rest of the class members. But the court held that as to class, that the damages were unable to be shown because there was no way for the plaintiff to show that there was a group of consumers out there that did not include a significant portion of people who were not deceived by these labels, that they understood Hawaiian-style kettle chips were not the same as made in Hawaii. And so, we typically think of the big decision is at the 12b-6 stage. If it's going to be you survive that, it's going to be on for the long haul. But when you get to the class stage, thinking about, is there going to be a big group of whatever class is supposedly out there that does not find this to be deceptive? And if so, are we able to use that to defeat class certification? And finally, I want to talk about ESG suits, which stand for environmental, sustainability, and governance. And these suits, I think, even within the past few years, went from you would see them from advocacy groups and really concerned citizens, and they seemed far-fetched or farcical or out there, and they were kind of brushed aside, and they were a nuisance to. They are there. There are a lot of them, and they are taking a bigger and bigger portion of litigation and are sticking around and making a difference. And a number of these have related to recycling claims. So Coca-Cola was sued by a number, I think, of 3 different suits related to its recycling claims, whether the bottles were actually 100% recyclable, whether the bottles were getting recycled, whether Coca-Cola, with its recycling push, was deceiving consumers into thinking they were doing better than they were. There's been a series of suits, especially related to seafood, about sustainability, whether seafood is sustainable or is raised in large-scale operations. So Red Lobster, Aldi have all been sued as it relates to seafood. And where we have typically in the past kind of thought that, well, courts don't really like to see these claims, we have seen them be more and more successful. And the Keurig case there have been a number of Keurig cases about whether those little coffee pods are recyclable or not, and whether they may technically be recyclable somewhere. Courts have held if they are overwhelmingly or majority not recyclable in most places, and consumers are really on their own to determine that and whether they are recyclable and if they actually will be recycled, that might be deceptive to a reasonable consumer, even if it's put on the label that it might be recyclable. And similarly, claims related to child and slave labor in supply chain. Starbucks was kept in the suit as to that because it had made claims about the lack of child and slave labor in its chocolate supply chain that basically plaintiffs were able to convince the court, at least at the Rule 12 stage, no manufacturer was able to make a claim that it could, 100% child or slave labor free, and based on the claims that those survived. So these are out there. They are bigger and bigger. They demand attention. We have been focusing on them more and more and are happy to think with you through them about that. So with all of that, I will turn it over to Alicia, who will take us into the wild and wonderful world of Prop 65.
Thank you, Ben. Hi, everyone. I'm really happy to be here with all of you today. And as Trent mentioned, I'm in our California office. I specialize in Prop 65. So what's going on in Prop 65 these days? First off, we have an update regarding, just wanted to keep you updated on the status of the changes to the short form warnings that were proposed. As you may remember, they were proposed back in January 2021 by the regulating agency over Prop 65 here in California, which is OEHA. And those changes included new limits to when a short form warning can be used, new content requirements for short form warnings, and a ban on the use of short form warnings for internet and sales catalogs specifically, as well as permissive use of short form warnings specifically on food labeling. So far, OEHA has not issued its final statement of reasons or any modifications to the short form warning amendments that came out back in January. So it's been a while, and we are monitoring this daily to see if there's anything new coming out of OEHA's offices. But at this point, they have not taken any additional actions beyond the initial statement of reasons in the proposed changes. The next step, as we mentioned previously, is that they will either issue a final statement of reasons or will issue modifications to the regulatory text if there are substantial modifications. And if there are modifications, they would need to do an additional comment period. So after OEHA does issue the final statement of reasons, which again could be following modifications and an additional comment period, then still one more step is for the Office of Administrative Law, commonly called OAL, to have 30 working days to officially approve the regulation. At this point, considering that we're now in the end of September, it's not likely that this regulation is going to be approved by OAL until sometime in 2022, and the warnings are required for products that are manufactured 1 year from the date of that OAL approval. That's the effective date as written, at least as written under the initially proposed regulations. So realistically, we're looking at sometime in 2022 when this will be effective. In other news, acrylamide is a hot topic again here in California, and many of you may have never actually heard of acrylamide, lucky for you, or had to deal with acrylamide before. If you're not in Prop 65 world, then you may not have. It is a listed chemical under Prop 65, and there's a duty to warn for it. And there's some issues that have been going on surrounding that we'll get into. But first, let's start off with what is acrylamide for those of you who are lucky enough not to know yet. Acrylamide is a chemical that forms during high temperature cooking, such as frying, roasting, and baking. It's not something that it would be in an unprocessed food. It forms through a natural chemical reaction between sugars and asparagine, which is an amino acid that's commonly contained in plant-based foods. And acrylamide is, as I said, a listed chemical under Prop 65. So in cases where a food product is processed in a way that would possibly create acrylamide, there is at this point a duty to warn under Prop 65. So some of the foods that acrylamide can be generated in are potatoes. So French fries are a common topic for acrylamide cases, almonds, such as roasted almonds, and grain-based foods, and pumpkin spice biscotti is something that could contain acrylamide. Even pumpkin spice Cheerios. I didn't know that existed until I looked it up. And of course, everyone's favorite, pumpkin spice lattes. But good news for all of you pumpkin spice latte lovers out there. Acrylamide, as well as other chemicals that are created in coffee during the roasting or brewing process, are now exempt from Prop 65 warnings. We have amended Prop 65 to exempt coffee in October of 2019, regardless of whether it happens to contain listed chemicals. That was enacted as Health and Safety Code Section 25704, and OEHA had acted in response to 10 years of litigation in a case that's entitled Council for Education and Research on Toxins, which is commonly known as CERT, versus Starbucks Corp. And many, countless other defendants who had coffee products that took place in the Los Angeles Superior Court. And there's long debates over acrylamide issues that went on in this case relating to coffee. CERT had claimed that a failure to warn under Prop 65 based on coffee containing acrylamide, which, as we said, is a listed chemical under Prop 65. However, all of the defendants argued that there is no causal link between coffee and cancer, and studies that the defendants put forward showed that in some cases, coffee is actually proven to reduce cancer risk. So when OEHA amended Prop 65 to exempt coffee, LASC, Los Angeles Superior Court, dismissed that entire action. Another case relating to acrylamide that's currently both in the Eastern District of California and in the Ninth Circuit on appeal, and is litigating some of these very same issues brought forth in that coffee case, is the California Chamber of Commerce versus Becerra being the Attorney General in California at the time that case was filed. So in 2019, the California Chamber of Commerce sued the California Attorney General for enforcing these Prop 65 claims relating to acrylamide. Cal Chamber's allegations in this case are that requiring companies to warn that acrylamide is, quote unquote, known to the state of California to cause cancer is a First Amendment violation. This is based on Cal Chamber pointing out that there's a complete lack of scientific evidence that shows that acrylamide can cause cancer in humans, specifically when ingested in foods. And then this would mean that Prop 65 is compelling false speech. As background, there's a good bit of scientific evidence showing a potential link between acrylamide being ingested and cancer in animals, but those studies have not translated into the same risk in humans. So the statement that it is known to cause cancer seems to be a false statement, as Cal Chamber is arguing. If it is a false statement, then Cal Chamber says that these Prop 65 warnings for acrylamide in food and beverage products are false, misleading, and highly controversial, that language that specifically makes out a First Amendment violation. The U.S. District Court actually issued a preliminary injunction on March 30th of 2021, and that injunction enjoins all new lawsuits to enforce Prop 65's warning requirements for acrylamide specifically in food and beverage products. Because again, the issue is whether or not acrylamide, when ingested, can actually cause cancer in humans. And the district court looked at evidence, in-depth evidence on this motion for preliminary injunction and found that there's not scientific proof in its preliminary injunction. An intervener in that case, though, Sept, again, who we just talked about as the plaintiff in the coffee case about acrylamide, appealed the ruling in the Ninth Circuit. And unfortunately, pretty quickly, the Ninth Circuit acted in response to Sept's request and stayed the injunction on May 27, 2021. The appeal is now fully briefed, so what's going to happen next in that case? We're watching it very closely, and we expect that oral argument will happen in the Ninth Circuit sometime in December of 2021 if things move along pretty quickly. And a ruling, if it does happen, oral argument does happen by the end of this year, would happen sometime in February of 2022 is kind of what we're thinking, but can't be sure, of course, how fast these things will move. Meanwhile, the U.S. District Court case on the same issue is proceeding on the merits, and we expect Cal Chamber is going to file a motion for summary judgment on those same First Amendment grounds brought up in their preliminary injunction motion. So finally, the newest thing on acrylamide, just last week on Friday, OEHA actually proposed new acrylamide-specific Prop 65 warnings. And as we get into this, you're going to see that this seems to be very closely tied to the Cal Chamber litigation and the issues in that case we just discussed. So on September 17th, last Friday, OEHA proposed new safe harbor warnings for acrylamide in food specifically. These new safe harbor warnings and regulations propose to add a new section to Prop 65 that includes tailored warning language for foods that contain acrylamide. The new subsection would be at section 25607.2, and then subsection B is the new subsection. The proposed new warning text includes two things. First, California warning in all caps. Note that it says specifically California and bold. And in addition to that, new language that's different from the standard safe harbor language. That is, consuming this product can expose you to acrylamide, a probable human carcinogen. Notice that it doesn't say known human carcinogen, formed in some foods during cooking or processing at high temperatures. Many factors affect your cancer risk, including the frequency and amount of the chemical consumed. And then the link here for more information is specifically to the Prop 65 page that gives information and guidance on acrylamide. Things to notice about this new warning text, again, is that language known to cause cancer in California that was specifically at issue and is the standard safe harbor warning, that language that was considered to be compelled false speech by the district court is not in this acrylamide warning. It's switched for probable human carcinogen. And there's a very much longer explanation about how it's formed in foods during cooking and processing rather than being naturally present in the foods, and the fact that many factors affect that risk, and pointing you to a page that gives information about acrylamide and all the various issues around that. So we'll be watching this very closely. We expect this to be highly litigated since this proposed change just came out, and there's still a question about whether or not this is actually true or if this is misleading speech. The new acrylamide specific warning is optional. You can still use the same standard known in California to cause cancer with the regular Prop 65 website link on foods that can potentially contain acrylamide. And the comment period for this is open. It's going to be open until November 8th, so still a good bit of time. OEHA has said that they're not planning to hold a public hearing, and they will only be scheduling one upon request. So I know we're going a couple minutes over. With that, I'm going to pass it back to Trent just to close us out.
Yep, thanks so much. Hope everyone has enjoyed our program. One thing I just wanted to note real quick, and this is going back to something Ben was talking about, was the environmental sustainability greenwashing claims. And I wanted to know, I just looked back at our sort of database, and the folks that are, the plaintiffs' attorneys that are filing these suits over the last 4 months, they're the heavy hitters. They're the Bursar and Fishers, the Dutrud and Staffiers, Kim Richmond in DC. So the fact that they're focusing on it, I think, means that we're about to see a lot more of those kinds. So pay attention to that. So once again, thanks everybody for showing up. Thanks to our panelists, really appreciate it. And don't be shy about reaching out to us if you have any questions or want to talk to us about anything. Thanks so much.